So we're just going to go through about 4 more cases that we've looked at and worked on. Some of them you've been involved in, maybe some of the counsel, the lawyers have been involved. Oh, sorry, no. And so let's take a look at them. As I say, there are a lot of common issues that come up in many of them. This Ethiopian one, as Martin referred to it before, was a case really that, again, has a long history and has been round the courts a couple of times. The woman, I think, had been in Japan since about the mid-2000s, 2006, I think, or something. Anyway, she was Amharic, which is the biggest group in Ethiopia. There's nothing marvellous about that. And a supporter of some of these political views. And she had set up a little coffee bar somewhere near and ran her business, unfortunately close to a police station. The police had got upset with her activities in promoting from her little restaurant parties that were anti-government. And so she had been subject to some pretty nasty treatment, including when she was detained by the police, I think on several occasions she was raped. She said she was raped. So that then she came here and was involved in some political activities here. In other words, what we say surplus while she was here. I don't know, it was protesting outside, I can't remember whether outside or outside the embassy, but certainly made her protests known here. The case went on for so long, as it was heard first instance, second instance, examination counsellors, and then to the district court, that in some ways, if it had been done correctly at the time of the hearing, looking forward to a return to Ethiopia, which is how I got, this case I've been involved in for some time. When I looked at it about 2 years ago and looked up some country information, the political scene had changed. And so when I looked at it, I said, oh, well, you've got to be a bit careful if you're going to take this case on appeal, because if you look now, there's a reasonably strong chance she wouldn't be a refugee. At this stage, of course, not knowing that the courts actually don't look forward. They look backwards. And so no wonder some of the people must have thought my response was a bit strange. But anyway, that's what happened. But they went ahead. You've got what we've called Ethiopia 1 decision. And it was a case that really took me down the track of looking at the English translations, because a very good English translation was done that allowed us to work on it and to look through it. And then you'll see in that case a number of the problems arose. Firstly, we've spoken about before the definition of being persecuted and so forth, and the way that claims sort of item by item, fact by fact were rejected instead of looking at the totality of the claim. It's amazing the way it was presented. And so it's one of those cases where I was just horrified and thought every paragraph, it wouldn't be done that way comparatively. And this went on for paragraph after paragraph. And things like, it's difficult to consider that this provides a basis for refugee status eligibility. Why is it difficult to consider? That's your job, for heaven's sake. They're just sort of appalling things for judges to say. And doesn't see this provides that she was actually subjected. Well, how do you know? It's just, we call it plucking things out of the sky. And that's not really what judges are meant to do. You're meant to do, if you're going to look at the facts, then for heaven's sake, look at the facts in more depth and don't come to conclusions that are based on maybes, difficult to consider, don't see this provide sort of thing. It may be the translations, I don't know, but it's just amazing terminology for judges to use. And it just, you really come to the conclusion, this person has a mindset, they're determined to decline it, and they're going to decline it on every ground that's put up, which is really what happens in that decision. So any sort of credibility analysis in it, which actually happens by sort of ridiculing every fact that was put up, is done without, as far as I can understand, certainly no appearance by the appellant. So the other side is not heard. The other side may have been heard, I don't know, at the objection, refugee counsellor level, or the immigration people, I don't know. But there's no mention of that in it. So you've got a whole, that third credibility assessment being done on the basis of information that's many, many years old. And some of the conclusions there are amazing. The conclusion about the, as I said, about, or was that in the, that might be in the second, yeah, that's in the, sorry, I'm jumping ahead. Anyway, there's no attempt to do it in the round. There's no objectivity in it. and of course, the test is done on that amazingly high standard that we were talking about before. So, as I said, understandably, the case went on appeal. But again, in the Ethiopia 2 case, which you've got there, again, the same, it's comparatively totally inconsistent with what would happen, particularly at a high court or what we would call a court of appeal level in virtually every country, or the Conseil d'État level in Europe. So at the Ethiopia 2 level, a court where you would normally expect them to deal with material errors of law, only not reassess facts. So that's my first question. Do you know people who've done cases at this, Sato Sensei? Do you know at the High Court level, do they usually delve into facts, or don't they? Is it, or were they purely looking at an error of law situation at the High Court level? What's the normal practice? Do you know?
No, not only the legal issues, but also the fact finding.
They do fact finding.
Yes.
At the Court of Appeal level.
Yes, Court of Appeal level. Okay. But Supreme Court is different. But
the Supreme Court is purely error of law.
Yes.
Okay.
Or constitutional issues.
Constitutional issues. Yes. Yeah, okay, that's understandable. Yes. Well, that's I must say that's somewhat surprising, but that's just a different comparison. It certainly doesn't happen in most because of the what's the best way? You're bid to have the best legal brains are at the Court of Appeal level, and so they then tend to be just purely legal issues they're dealing with rather than fact-finding issues. So, but having done the fact-finding issues, again, the other side is simply not heard. So how they could go ahead purely on the papers, retrospective papers, and conclude something without hearing the other side is just a straight out fundamental breach of the fairness rules, and that you just don't do that, and you because you're not hearing the other side. And even then, a number of the comments made like, it is impossible to find. Well, why is it impossible to find? You've got to make conclusions. You just don't duck the issue because it looks hard, particularly at the High Court level. Sorry to sound quite critical, but I'm just going through it as if I was a reviewing judge. And anyway, and then this one goes on, probably some of the most amazing things, and said whether the PTSD was linked to the rapes themselves, and reaching a conclusion on that would be considered a very serious error of law comparatively, as on the face of it, the judge is making a medical or psychiatric conclusion without the expertise of being, or if he was, he should have disclosed that he had super degrees in medicine or psychiatry. And if he didn't, In many cases, quite no harm in getting such evidence. But that's what you've got to ask for. And so maybe council should have done that as well and said, if you are going to take the issues of the rape and whether it's linked to the PTSD, then I need medical evidence from it. All right, the psychiatrist mightn't be able to be firm about it, but at least you take advice and you hear the other side. So it's a classic case of really being wrong in law where judges are taking on expertise they simply don't have. And it's wrong to do that, and fairly logically wrong, I think. Okay, is there any further comment on those two cases? They're rather sad cases, I think, but any views that you think they've got right, wrong or indifferent? Yes?
Your assessment is very accurate. It is part of a wider problem with these two decisions. Look, what is the relevance of her being raped in the past, and what is the relevance of her having PTSD? What is a refugee case about? A refugee case is about an assessment of the risk in the future. All that these two decisions do is talk about what happened in the past. There is not a word of genuine assessment about what the risk to her might be in the future. There's a lot of talk about not believing that she was raped or that it caused her to get pregnant. There's a lot of cynicism about the fact that she might have run her cafe for a couple of years in the same town as the police station. Do you have any idea how big Addis Ababa is? It's nearly the size of Tokyo. Yeah. So we're not really talking about somebody who's living next door to the police station necessarily at all. But I want to read you something. This is from the first of the two decisions. And this really tells me everything I need to know about what was in the judges' minds. This is the last, under heading 2, this is the last of the credibility findings they make about her. In addition, you know what the EPRDF is? It's a political party in Ethiopia, okay? In addition, considering the fact that the EPRDF and its supporting parties won almost all the seats of the People's Congress, lower house, in the national election in 2010, and all the seats in the subsequent national election in 2015, it is impossible to find that she was raped due to her expression of opposition against the EPRDF.
What?
This is nonsense.
It's sad. Yep.
It is terribly sad. These are judges, well, this is a judge straining for reasons to decline this case. This is not a person grappling with reality at all. But nowhere in here do they ask the question, what will happen to this woman if she goes back? That's the real failure of these two cases. They're obsessed with making findings about the past. Nobody stops to say, well, what are the facts that we do accept? Yep. And do they make her a refugee? In every single case you ever look at, no matter how many lies the person tells you, there will be some things that you accept. I will give you a really simple example. I'm sure you all know of the long, terrible civil war in Sri Lanka that went from 1983 to 2009. You know, hundreds of thousands of people killed. And it was especially terrible in the late 1990s, leading up to the ceasefire in 2002. A lot of Sri Lankan young Tamil men left And they came to New Zealand, and many of them told silly stories. They made up lies. People get together in their community while they're waiting for their cases to be heard, and somebody says, "Oh no, you can't tell them that. Oh, that'll never work. No, you've got to tell them such and such." So we get given a lot of silly rubbish. And both Allan and I, we had young Tamil men from the north of Sri Lanka sit in front of us and tell us a pack of lies. And at the end of recording that they had told us a pack of lies, we would still say, what we do accept is that this is a young Tamil male from the north of Sri Lanka. And those facts alone put him at risk to the real chance level of being persecuted. In spite of the lies, what facts we do believe still make him a refugee. So this is why in this Ethiopian case, it was so important to ask what was believed and did that make her a refugee. And it just never happened as far as I can see.
No. And in fact, Martin will come back to this one in a minute, the Syrian one. Again, it's one I've quit. That's virtually what happened there. There's a huge assessment of facts, retrospectively again, and a lot of individual rejection of various parts of the claim. But even at the end of that, nobody sat down and said, what have we got left with? A Syrian man who comes from an area now occupied by the Assad forces, or the Russians, or a combination of them.
A Syrian Kurd.
A Syrian Kurd, make it even more of a problem. So, and whose brothers, 3 of them, were granted refugee status in the UK. So somebody thought their story was correct.
And did the judges in the Syrian case in Japan, did they ask to see the English decisions, to see what the reasoning was? I can't see that they did.
No. And there are some things in this case where credibility probably was at issue about his avoiding military service and various things like that. But even avoiding military service, while it's recognised that states can call to do that, if this guy lived in an area that was occupied by the rebel forces, how is he going to carry out or his military service? And he was involved in a group that was supporting the rebels. So the ability of him to undertake military service is just a joke. But that's just not brought into it.
In the decision, they cite country information which records that the Syrian army commits human rights abuses against its civilian population. Now, if I said to any of you, you're required to do your military service, and we're going to send you out in the army to commit human rights abuses, are you prepared to do that? No, of course you're not. It is persecution to be asked, to be required to commit human rights abuses. And do they discuss this? No. They just they say, oh, we think he's off. We think he's really come to Japan because he doesn't want to do military service. They never grapple with why he doesn't want to do it.
Now, there's some amazing things, and they do take into account, no doubt put up by their council, a lot of quite good COI, including a very good and well-researched paper, which I've seen in other cases, from the UNHCR, which says that virtually everybody in the same predicament as this person from Syria is deserving of refugee status. And they just ignored it. So you've got 3 brothers accepted, plus that, and plus that he's Kurdish, and plus that he comes from a rebel-held area. To say that he wasn't a refugee is absolutely amazing that they could come to that and still sleep at night. It really is an amazing decision. It's probably the worst of all the decisions that we've looked at if you're going to look at it comparatively. Okay, anything else you want? It's just a quote from it. It says the UNHCR report of 2014, so they, again, we're going backwards. They didn't, if the only thing that's wrong with it, they didn't assess it in 2018, was it, or 2019? 2018. On what was the risks at this time. So what the report had said was, and it's quoted in here, page 26, the majority of Syrians seeking international protection have a well-founded fear of being persecuted in connection with one of the 5 convention grounds. Political opinion would strike you immediately, or race in this case as well, and therefore they are likely to meet the requirements of the refugee refugee under the Refugee Convention. So you couldn't get a more blunt statement, but there's no attempt to rebut that later or say why the UNHCR doesn't know what it's talking about. But they're probably the most well-informed group that are there because they're at the border and there's hundreds of thousands of them being looked after by the UNHCR. So that doesn't even get any treatment in the case. So sorry to be a bit savage on that case, but it really is quite an amazing decision to reach. And
the one blessing to come out of it is that at least this man had been granted humanitarian protection in Japan.
Yep.
He didn't get sent back. I mean, that's something, but this reasoning is just wrong.
It's I don't know if any of the lawyers here might be able to tell me. If people get a humanitarian grant like that, which is a domestic provision, I presume, under domestic law, can they appeal? In other words, can they make what we used to call in the UK an upgrade appeal to get refugee status instead of it? In other words, the appeal could just be that
that's what this was.
Yeah, I know, but can it keep on going? As I mean,
somebody told me someone told me last night that he decided not to. He could have gone further, but he just decided not to. Yeah.
Because quite commonly, until they brought in subsidiary protection in the UK, because of the bundle of rights you get, as we said earlier on, Refugee Convention is not just 1A2 and Article 33. It's the whole bundle of rights that come with it, the right to education, the right to social security, and so many other things, that which you, instead of just plain, as we call it, plain vanilla non-refoulement, they want the upgrade of all the rights, quite correctly. So we used to get a number of those cases in the early 2000s in the UK. That's why I asked the question, really. Okay, so again, this is another case where this sort of what I would call random statements, and it is appropriate to construe the being persecuted thing, that it means attack. That's where I got that quote from before. And then in respect of the evidence by the council, we've discussed this I think the other day, since those recognised are given favourable legal status, as being to acquire permanent residence. Therefore, refugee status is a profit-making disposition and as such bears a burden of proof about fulfilling this and for eligibility. So maybe it's just the wording, but bringing profitability into such a humanitarian field is strange wording. Now, that may just be in the translation. And sure, it's a beneficial status, but I think this is where the using of domestic administrative law has just got completely awry or out of step with this being an international humanitarian convention, and so thereby saying that it's the wrong or totally inappropriate civil standards to use as in a refugee case. And that's, again, as we've seen so many times, using these basically domestic administrative rules to take them is what puts them on the wrong track. I think I said when we started, it's a bit like trying to play rugby on a basketball court. According to hockey rules, it just will not work, and that's the problem why it doesn't work.
We're not saying. Sorry, I'll just go back.
Sorry. There. Whoop.
We're not saying that this bit is wrong.
No.
The claimant should bear the responsibility for establishing the claim. We just prefer that you don't go away using this language of profit making. Yes, it is a status that is a benefit to him and can lead to other benefits. But actually that is not the reason why the burden of proof should lie with the claimant. The burden of proof should lie with the claimant because he or she is the only one capable of establishing the case. Only they know what happened. And early on in New Zealand, we had a lawyer turn up in front of Allan with his client, and he said, "No, my client has put in his statement, he's not going to answer any questions, you have to prove his claim is not true." And Allan said, "No, we don't." and the High Court agreed with us. It is clearly the responsibility to establish the claim lies with the claimant. But this language comes from elsewhere. You don't need this to get to this conclusion.
And of course, the other thing is, well, you knew that when you signed the convention, that you were going to give them, that's the whole benefit. Why sign it? Because you knew that it was to give people surrogate protection. You don't need all the favourable stuff. You've already agreed to that by signing the convention. So you can see why it's rather confusing and circular thinking to get to there. Is there any comments on that, or were they?
Is it all crystal clear?
Simple, well, self-evident, I was going to say. So yeah, it's the same thing we're just saying on this slide. Again, it's an inappropriate use of domestic law standards. Instead of recognising, as I said before, the unique differences. I think we've been through all of this, that's pretty well, yes, that's what I said, yet it has declined. It is vastly out of step, as we said, with international comparisons. Okay, the next case we're going to,
I'm afraid they got this crazy idea from the English.
Yeah.
The English are obsessed with this concept of civil war. You can't be a refugee if you're at risk because of a civil war, a generalized risk of violence. It wanders so far away from the convention definition of a refugee. Keep coming back to Article 1A2. Does this person face a real chance of being persecuted? If I'm sitting in a Syrian village and they're dropping barrel bombs from aircraft on my village, yep, I've got a real chance of being persecuted. And they may not be targeting me specifically, but they are targeting all my people, and I'm one of them. The English created this nonsense, and I'm angry with them for doing so.
It comes back to what we spoke about. The convention says being persecuted. And unfortunately, in the UK, even though probably the 7,000 or 8,000 decisions that I wrote over there, I said being persecuted every time, just to make sure they say all the time persecution. So it's the same problem that you've got here of using a generalised term, which then says, oh, well, it's a risk of persecution. No, it's a well-founded fear of somebody with this profile going back and being persecuted. So it does bring it to the individual. You're quite right, but the persecution, if it's general or not general, if the bomb goes off and kills you, because somebody with your profile or your situation is back there, you're still dead. and so you are being persecuted. So it's just they just don't read the convention. That it's as simple as that. You know, I had endless arguments when I was in the court there. Nobody ever appealed me when I did it this way. Syria, I was there before the Syrian thing started, but this was happening all around the world. Generalised persecution, Somalia.
What do you think it really is? Why do you think the English invent these strange concepts? You don't have. I mean, you are right. It is what we call the floodgates fear. Yep. They fear that if they grant this person, they'll have to grant every Syrian. Let me explain something to you. The floodgates is by and large a myth. We granted refugee status to an Iranian homosexual in 2002 simply because he was homosexual. And gay people cannot live openly in Iran. That they have to deny their sexuality. There are serious breaches of their right to privacy. They have to live a life pretending to be somebody that they're not. And if they don't do that, they are at risk of very serious harm. Now, that is the case for every gay person in Iran. 10% of any population is gay. 10% of Iranians are gay. Did the floodgates open when we said being Iranian and gay is enough? No. We've had about 3 gay Iranian cases since 2002. It is not true that people rush to leave their country at the first drop of a hat. Now, Syria is of course it's a serious problem, and half a million Syrians or more have flooded into Europe. I fully accept that. And that is what the Refugee Convention was designed to do. What were you going to do in 1940? Were you going to say to the first million Jews who fled from Nazi Germany, no, sorry, there's too many of you. You'll have to go back. Of course not. Sometimes there are massive population shifts. The Refugee Convention requires us to deal with them, not to deny their rights on a specious pretense, which is what the English do. No, but there are massive practical difficulties, and it's not the case that all of Syria has left the country. Yes, large numbers have, and large numbers are spread across Europe and around the world. My first point was simply to point out that the floodgates argument, in other words, because you grant somebody, it does not lead to a flood of people coming. And that is equally applicable to Syria. Nobody's left Syria because somebody in England said, oh, we'll give refugee status to this guy because he's Syrian. That's not why anybody's left Syria. I'm quite sure that the correct stance being taken by Germany and the incorrect stance being taken by all the countries in between and most other countries in Europe, that combined, that contributed to a pull factor towards Germany. But so what?
It's the massive movement, and when there is massive movement of people like that across borders, then that's why they make blanket decisions, because simply going through and doing 1 million cases, you'd never get through the course and you'd never get done. And that's what happens with the UNHCR, Great Lakes situation, you know, in the 90s. There were millions of people, hundreds of thousands of them moving. So the UNHCR went in there and just blanketly said, yes, if you're, Tutsi and so forth, and come Yeah, and so you're going to be a refugee, and so that's what happens in those type of mass arrivals. So the pull factor.
The problem was not Germany.
Yeah.
The problem was the rest of Europe not doing the same thing. There would have been no pull to Germany if everybody was responsible. Refugees need somewhere safe to go. These countries signed the Refugee Convention. Yes, it's a problem. It needs to be dealt with. Are you seriously saying that you would deny people refugee status just because it's inconvenient? Because there's too many of them? No, I'm not agreeing with you. I'm saying that the Syrian situation in Europe is contributed to by a wide range of factors. You cannot possibly think that it would have been better for Germany to be less open to taking refugees. Is that what you're suggesting?
Yeah, I think, sorry, just intervention. This is also the reason of this Pacific solution or the Australian or sort of just kind of a political sort of discussions. But regarding interpretation of the convention, I don't know how does this political factors should be allowed for each state. Maybe, of course, depend on the state because sovereignties. But your argument is valid, especially in case of the Australia. So long seashores and you cannot protect such a sort of invasion of the illegal sort of migrants, just disguising asylum seekers, something like that. That is the argument of the Australian to just intercept of any boat for something like that. So that itself is from the convention point of view, it's a problem for that. But it is true. That's why also Japan is also very negatively narrowly for interpreted something like that. This is definitely some kind of political consideration, especially Minister of Justice. Minister of Justice also just of the sovereign power, so also considering for this kind of balancing. So the judge is also how judge can consider this.
That's really what I was going to say. There's two areas here. There's a judicial decision in front of you, which I think we've told you here. But the political reality of so many of these things is which is what happened in Europe and what happened in Australia. And the Australian one is a tricky one, difficult one to deal with. Not really, I don't think, for the reasons that they've got a long border or anything else. It's more that to me, the difficulty is, for the Australian one, is it's what happens to these people. And they die and they have these horrible trips on the boats and everything else as the way of getting across from Indonesia to Australia, and they're dying and doing that. That is the hard part to deal with. The refugee side of it actually is pretty easy if they go through a claim system there that's worthwhile. But the difficulty is in coming up with arguments that somehow still protect these people, stop them getting on boats to get there, because you can see there's an argument there that if the Australians didn't do something about it, then they're going to get a lot more people dying at sea. So, but the way they went about it, the utterly draconian way they went about it, is where the problem arises. So that there's got to be better solutions. And those sort of solutions, unfortunately, as in same in Europe, where you get cooperations between nations. And in this current world, that doesn't happen. And so that's what causes the problem. It doesn't mean to say that the Syrians are not refugees. It doesn't mean to say that the Sri Lankans and so forth who are on their boats are not refugees. It's just how those things are dealt with in the current political environment. And we're judges, we're not politicians. So it's really, we deal with the cases that come before us, and we want to uphold the rule of law, which nations sign and so forth. But when these political interventions come in, it's a totally different argument. And as human rights workers and people who work in this field, yes, we agree with you that it's problematic. But I still don't see I don't see it because judges make these decisions on individual cases. It's much of a pull factor. That's, but I think that's debatable. As soon as you go down that argument, you immediately come to the country is not sharing these things. Therefore, there's a totally political view of it. And people don't want them, and this whole anti-migrant thing starts. And so, all we're saying is that judges have got to stick to doing their job and observing the rule of law, whether you like it or not. And so if you're dealing with an individual case, you still do it on the law. You don't do it because governments say, oh, we don't want too many, or there's various parties in the government. That's the hard part.
Judges are often the last line of defence for the rule of law.
One more point I would like to raise the issue that just Martin suggested, the 1940s, the Jewish sort of refugees. Yes, that is the history. That is the reason for the convention was adopted in Geneva. But this was 1951. At that time, also Professor Hathaway also admitted some sort of a political sort of motivation, especially the Cold War started, and then this Western country tried to use this convention to just bashing the Soviet Union and the socialist countries. So in this sense, more or less, this 1951 convention is considered to be just block the communist countries. So in this sense, more or less, the individual sort of a target political profile. Sometimes political profile is also discussed when I was working at UNHCR or something like that. Right. So in this sense, profile means kind of a targeting. So how this be a risky means how the recognize as an enemy of the state or something like that. So in such a kind of a probably background would be still shared. And of course, now the Syrian and the Rohingya and many sort of, because of the civil war, so our age is post-Cold War time, so reinterpret this convention. So mostly the Europeans and so on. From my point of view, just fitting in this reality of the world, or just reason of the convention. But Japan is so isolated island, maybe same as New Zealand, but our position is more or less still also some officers also arguing North Korea. If something happened, we have to receive all North Korea and something like that. That is, they are really thinking seriously some sort of thing. So in such a way to just to exclude this interpretation in the Cold War time of the not so fitting in this global world for burden sharing, something like that.
Well, you look at countries like Uganda, which host staggering numbers of refugees, and they do so with a smile. It is, they can barely afford their own domestic economy, but they harbour hundreds of thousands of refugees. Kenya has been hosting Somali refugees for 30 years. Half of Nairobi is now made up of Somalis.
It depends how you view it. I had the, I suppose, privilege in some ways, some years ago, to Tanzania in the time just after the Great Lakes. There were 600,000 people in Tanzania along the lake there, being protected by Tanzania in the main. And so, you see that argument and you think, being selective, if it's an accident of geography, then some countries do it. That's why the OAU is an amazing document that allows those sorts of things to happen without being too much of an argument. They were just accepted. They were processing people there. bizarrely, there were when I was there were groups of small boats arriving, mainly Burundis on it. And these Burundians, I said, oh, are you going to register them? Oh no, they're already registered. They're just coming home to see their wives and families for the weekend. And they will then go back to war on Monday by sailing across, because I don't know if you've been to that part of the world, but Lake Tanganyika is huge. It's about the size of Japan. And so it's a big piece of ocean, really, or a big lake to get across. But, well, they didn't go across the whole thing, they just went a corner. But that's what happens in those sort of places. But still, the UNHCR was there and they were protecting them with the help of the Tanzanians. And that's the people we were talking to was actually about refugee rights. And in amongst those 600,000, there was a team of about 60 or 70 we trained, but there were more than that, there was about 600, what they called barefoot judges, who went around, that's what they were called, literally barefoot judges. And so they went round in the camps and dealt with all sorts of issues, according to Tanzanian law, as best they could, and were always trying to ensure the refugee rights, believe it or not, as part of it. And that's what we went to do, was to try and ensure that they understood, long before Hathaway wrote his book, about refugee rights and what they were about. I know because I went out there and didn't know that was what I was going to be asked. So I spent a whole weekend and several evenings just finding out about refugee rights and the rest of the convention so as I could go out and sound sensible. But yeah, anyway, we could debate it all night, I think, that sort of issue. Yes, sorry. Yeah, you're right. The Article 15(1)(c) has given way to a legal monstrosity, frankly. It's because it's about generalised violence. But all the courts around Europe have tried every way possible to avoid that sort of, to allow them subsidiary protection under there. Before I left, we had a few cases on it where we were taking the more, what Martin was sort of saying, where it's not just generalised violence, you've got to look at them as a refugee, and most of them were refugees, the few that we were involved in. But, and that's what the QD was trying to do, was to extend it. But then many people started arriving, so the courts were pressured, or the first instance people were pressured to restrict 15(1)(c) as a result of that. So you're right, it's not that simple sitting here from a distance. They're not just dealing with the Refugee Convention. In fact, you're not at all, because you can't be a refugee within the EU, and so they're all done under the QD to deal with it. So yeah, it's like I said earlier on, you've got to, well, that wasn't you, it was when I was talking this afternoon with the MOJ, there are levels you've got to go through to get to the reality of where you're comparing apples with apples, or like with like. And until you get to that stage, we can't really have a discussion. You can have at international refugee law level, you've got to try and eliminate those issues, which is what we try and do in the IRMJ all the time. That's one of the things, is to unscramble the Okiyamiga, to unscramble the omelette, as we say, and so that you can understand each part of it. So, and you don't end up with just a mix of broken eggs. That's the problem.
Myanmar.
Okay, Myanmar. Let's just come through one of the last cases we were going to look at. This one, sadly, is what I've termed a 20-year tragedy of unending dysfunction. This fellow arrived in Japan via Korea in about 1998 on a temporary visa. He had problems in Myanmar, as so many of them do, and he undertook an education course, I think, in Korea, and he finished that, and then they said, time to go home. he didn't want to go back because he had a fear of being persecuted and maltreated. And so he came to Japan and stayed here. And again, nothing happened until 2004 to 2004, when suddenly the immigration officers found him, knocked on his door or whatever they did, and put him in detention and kept him in detention for about 15 months. And he lodged a claim. So 2004, and the case is still going, as you can see, in 2018. And technically, for the reasons I said before, we've said all along, it's declaratory and you should do the decision as of now. Nobody knows whether he still is, whether he is a refugee. There are no doubt times when he was, but the decisions made historically all the time by the courts have helped nobody. As I say here, not the claimants, not the states, not the lawyers, not the general public who pay the taxes. And yet 20 years later, here you've got this man still here and probably about to lodge another claim, I don't know, because the system doesn't work. And so that's the worrying thing from a case like the Myanmar one. It's just not serving its purpose when that takes place. First of all, you could say, first off, well, you should have a better system when people arrive, that you check up on them so that they're returned earlier. Maybe that's right, but people do fly under the radar. Here, I gather there's 3 or 4 million people that are undeclared or unregistered or working in Japan. So then when they do come to this and make a claim, then the system should allow them, first of all, to be assessed at the time when they make the claim, preferably if they're not criminals, not in a detention centre. And so on it goes. They eventually had to release him, so he gets released. Then he gets some short-term visa, which is no doubt renewed from time to time. And then he takes his claim. It goes all the way right through to, I think, about 2008, isn't it, or something, where he's declined. Right, I think he went all the way to the Supreme Court, didn't he? Anyway, and then because when you look back historically, nobody actually correctly found out whether he was a refugee at the time he was making the claim, so he started all over again. And this time it took about 10 years to get through the whole system. So this is what I started when I first talked to you in the first course. It's gone the full circle. So to say that this RSD system and everything related to it is causing the abuse. There are probably times when this guy was abusive of the system. There were probably times when he was a refugee. But unless you've got a system that works, I don't care what country you're in, then you're just asking for it to be abused, because it's just an incentive to stay here and work illegally, and they just lodge another claim and another claim, and not have a system. We were discussing it briefly with the MOJ. There are systems around. There are abilities to do it, and that these problems can be overcome. But if your system has this problem of looking backwards instead of looking at the current situation, it'll just go on and on and on. And there'll be a continuing abuse. And so even legislating to say, right, you can't make subsequent claims, that won't solve the problem. That is, what you're creating then is an artificial system by domestic legislation. It doesn't mean to say they'll go away because they still want to get paid, or they've got family here, or they, after 20 years, it's not recognising the reality. So the need is still the same. Get it right first time, as I said 6 weeks ago, or whatever it was, that the country that invented get it right first time wants to try and get it right. But it really is a time for change, I think. And so from an academic viewpoint, which is what we've been doing here, debating it, that's the argument that we would urge. But that's really for Japan to decide and to work out if it's happy to live with this dysfunction, or would you just rather keep on going with a dysfunctional system. So that's what I say, it's in nobody's interest. So is anything specific that you want to raise out of the Myanmar case, or anything in my statements which might be somewhat over the top? As I've got, as you can see, in the numbers here, 13 years, including some post-dated evidence that was accepted at one time, but it still doesn't determine prospectively whether he was a refugee in 2017, 2018. Again and again, as I said, this is the same type of thing, where you get these random statements, no reason to believe, difficult to think would be likely, difficult to recognise, impossible to assume, impossible to find, etc. Go on. This is the beauty of having one assessment of credibility, where you put what you believe and what you don't believe together, or what you accept, then using that to make a risk test on one standard, real chance, real risk, reasonable possibility, or whatever you like to call it. But going through and individually doing any of these, it just won't work, and it's just not clear thinking. So, as I said, comparatively, it would be overturned on every one of these statements, if not in its totality. So that's comparatively. I'm not trying to be rude or anything about it. That is the reality of the comparison. Oh, okay, that's what I'm just saying. Finally, revisiting, I just checked to see which from that structured paper that you got originally how did it line up against the internationally agreed credibility standards, and it's just about got about, I think I found it was a breach of about 15 or 16 of about 40 standards. So it would be liable to be overturned on all those grounds, I think. Okay, any other comments? So, yes, sorry. You're right. Yep. You're 100% correct, of course. First of all, you've got to have the will to change and get it right. As far as the judges, I accept half your argument, but I don't accept the other half. I accept the Japanese language problem, yes. I think that's pretty fundamental to it, as it is with every other foreign language around the world. And that is problematic, because I said at the start, fortunately or unfortunately, about 95% probably of the COI is in English. And the jurisprudence, I don't know, 60%, 70% probably is in English, the rest is in European, African, well, they're probably still European languages in South America, but so yeah, or they were, is probably a better way of putting it. But yeah, so that's problematic, but that's the same if you're doing intellectual protection cases. It's exactly the same as if you're doing law of the sea cases. It's exactly the same as you're doing children's Hague Convention cases. Where's the difference? You have to do the translation to get the answer.
I can solve your problem for you. Persuade the Japanese government to set up a specialist tribunal.
That's the problem, yeah.
Staffed with expert Japanese judges who are well trained in refugee and migration law, and all of whom have English as a second language. All your problems would go away.
Yeah. Yes, right. That's the way to fix it is not the court. The way to fix it is an independent tribunal. or call it what you like, subcourt, exactly as the professors at Hongo said to Sato Sensei Nova, they're setting up one for intellectual property and copyright. Well, if it's good enough for that, why is it not good enough for refugees? It's the same sort of thing, it's just another international convention you're applying.
I can see a room full of the best qualified people in Japan to be on that tribunal.
Yeah.
Japan is not the only country suffers with non-native English country. So we had very similar, well, we still have a very similar problem. And actually, Korean lawyers took a very creative approach to solve, not to solve but assist this problem. They request COI as a factual inquiry to the court, and court sends it to the UNHCR. I don't know if the UNHCR in Japan does the same job, but the lawyers sometimes they have specific case in mind from European court, for example, to support their claim, and they ask this as a factual inquiry question for UNHCR to submit a COI document, which includes those federal decisions to support their claim or give a definition of a more standardized concept of refugee protection. So Korean is not an official language to UN, but because Korean language is the only language used in Korean court, we provided unofficially translated document. So within English is the original document, then translate that into Korean, and then submit it to the court. So the court can take a look at all those international documents and case law as well. So that was one of the approach. And lawyers put a lot of effort to translate all these foreign cases, foreign international documents or international instruments that support why they should be protected or what kind of claims they should look at. So maybe that will be another way of approach to assist the problem. Or
You have to start creating a database of COI that's been translated. Well, we have a problem accessing information in Chinese. I often need it for Chinese cases. I can't access it myself. The solution was we employed a Chinese expert who can access the information for us and provide me with a translated copy.
Well, I think real issue is not just language. I think this real issue is priorities issues. That means in Japan, Korea, as a size of this population of the asylum seekers, the refugees are quite small in per capita. Of course, New Zealand is also a small country. Per capita probably is bigger than the Japan and Korea. So in this sense, priority is very low. Cost and benefit. So in this sense, yeah, I also recommended the same also more than 20 or 30 years ago. But everyone says no such incentive to create this kind of a very luxurious court. So how New Zealand could pay for this kind of such a luxurious process? Japanese system is probably...
I promise you it's not luxurious.
Honestly...
Comparatively, the per capita for the taxpayers' point of view.
That's just nonsense. Because your system now is costing you probably 50 times what it should.
Yeah.
If you do it right first time, it'll cost you 50th of it. So that is nonsense, those arguments. It's also nonsense to say there's not many of them comparative to the rest of us. They're just human beings like everyone that's ever appeared for me. Perhaps apart from one or two terrorists, you've got to treat them with human dignity. They're people. Hello, you can talk to them and they will respond if you take the right approach. And even if they're even if they're migrants wanting to pose as refugees, when you talk to them and explain that they're not, I have never had an occasion where they say, fine, there's no aggressiveness or anything in it. They just want their position sorted out. It's as simple as that. And if judges and everybody else is trained to do that and to treat them as human beings, not nasties or people you don't like or people of the wrong colour or the wrong shape or the wrong size, then it works. It's that simple. It is not complicated. And so that's why do you have a human security department here?
Yeah.
Well, all these things, that's what they're
I'm just talking about the
say.
practical
Yeah.
way of course I agree with you. But how to actually create this kind of new system so in this sense, I think now is a good chance for us to reconsider, because now we need more for foreigners to support the Japanese society, something like that, some kind of just kind of now the game changing.
Yep.
So
it doesn't matter what the driver is, as long as he's pointing in the right direction. And that's exactly what you're saying. If the driver is we need more labour here, then legitimise that labour and bring them in here under correct systems. And there's no reason why you can't run your refugee thing in the background to that. You can have like we have in New Zealand. That's why we changed the name of the association, because you're always dealing with migration and refugee cases in virtually every case.
10 years ago, we started the human security program. Not so many foreign students like you. Now we are full of foreign students. So increasing the numbers. I think, I don't know, how many are you refugee or asylum seekers? Unfortunately, no one. So I hope, maybe next 10 years we have some in a class of.
We've got to grant a few first before that happens.
So that's more sympathy, more awareness we promoted, I think. So, so these kind of things discussed actually the last class of the Sunday. So that is please you come and discuss more practical things.
Exactly. Thank you for that. I was just going to do the same advertisement. On Sunday, the chat there will be far more free and open, we hope. All Martin and I will do is just put a few bullet points together, and by all means, if any of you want to add bullet points to it.
We have more citizens.
We have more citizens there to debate it with. And all we're saying is, can international refugee law and matters related to it assist Japan in the future? That's really what the program will be about. And please come along, particularly if you're a student. It's part of the course. And anybody else that wants to come, it's an open forum. And it's just there and it's very much just an academic debate. It's not meant to be, I suppose it is it Chatham House rules you want there or not?
Yes,
you do.
Chatham House rules.
Yeah, okay. So, which means what's said, in other words, feel free to say what you want. Chatham House rules just means...
Also, if you would come to 16th, the Saturday 16th, in our keynote speech, we have a commissioner, the top of the new agency. This is a Immigration Services Agency, who is the top of this, Ministry of Justice determination of refugee status. Actually, for this, supposed to give some advice to the Minister of Justice. Minister of Justice still have authority to decide, but of course, the head of the immigration agency is actually really deciding this process. Now they are changing or they are reforming. I think so. There's a good chance. So she is invited as a greeting for opening speech. So if you're interested, please come and ask her any question. I don't know if she can answer to your question, but
we'll answer.
Yeah.
Can I add something just to leave you to think about, and we can talk about it on Sunday night. But there's a second thing that Japan needs to do. Japan needs to close off its backlog. There are, 20,000 cases? Seal them off as a backlog and create a team of people to deal with them. And have your ordinary immigration officers be able to start with, refugee officers, be able to start hearing cases as soon as they come in. This is the only way that you will stop people using the refugee system as a delaying tactic to get visas. You need to put a special team onto getting rid of the backlog, but your ordinary officers will start dealing with what we call flow cases, so that people's new refugee claims are dealt with straight away. And that is very likely to have a good impact on the number of silly claims or claims that are only put in to buy time. Not difficult to do, just needs money.
Oh, exactly. Yes.
You carry.
No. I think that is wrong. Probably even if we call a special court or something like that, if this court is under the Supreme Court hierarchy, this is of course allowed by the our Constitution.
Yep.
Now, our Constitution never allowed the military court, which is independent from the Supreme Court. That kind of thing.
That's what it was aimed at, wasn't it?
And if it the tribunal would definitely need to be in the court structure so that appeals can lie from it to the superior courts.
But quite unique, probably the normal or ordinary court will find the facts in the past and that's right. But this court will just
build expertise.
Future. That is really not the trained normal judges or persons.
Oh, no reason why they can't. But anyway,
it's a good practice, I think.
Yeah.
You just call them tribunal members, not judges, and then you only have
you
only have to pay them half as much.
That's the way they keep the cost down. I assure, actually, the New Zealand system, having been chair of it for some time and involved in both the money and they're not quite so. The new system doesn't bring the chair into being involved with how it's run. You'd be amazed how little it costs to run and to get. I think we were doing something like combining all of them, what's now in the IPT, something like well over 1,000 cases a year, dealt with by up to, I think, 30 or 40 members. Well, let's say there were about 10 full-time equivalent in them. The whole system cost, now let me think, all right, it's a bit out of date, but it was cost $2.5 million to run the New Zealand dollars. That's about $1.5 million US dollars per year. It's peanuts. And all right, well, inflation, not been much inflation since 2000, so maybe it's 2 million. And then the other ones were less. They were about 1.5 million to run. That includes staff, everything. So all up, they were costing about 4 million New Zealand dollars, which is about 3 million US or less. All right? So it's just nonsense to say that it's cheap if you do it properly. If you let it go and you've got 20,000 and you've got backlogs to deal with, it'll cost you plenty. But one could say, well, you deserve that because you never did it right in the first place. If you were running a business and allowed that to happen, I know nobody likes this story in New Zealand. I assure you, you wouldn't get away with it running Mazda. You wouldn't get away with it running Mr. Toyota. Mr. Sony wouldn't like it either. So it's just not business. That's what I've always tried to say. I cannot work it out. For a country that's so good at business, that here's something that the answers are fairly obvious, but there's no will, by the look of it, to carry it out. So you're right, that's the thing that needs to change. The answers are there, and do it properly, as Martin said. We got paid about a third what a judge got paid to do probably a harder job.
Still do.
Still do. Yeah, and that's why it was attractive to go to the UK, because I got paid as if I was a judge. Okay. There was one case that we had left called the Sri Lankan case. I just called it RFT, Right to Fair Trial. This is one you brought to our attention. Martin has had a look at it. I've had a small look at it. You want to introduce it first and tell us why you think it's of concern? from the point of view of refugee issues, did the guy want to claim refugee status?
Yeah.
Do you know that or not?
Yeah. Yeah.
Ah, that's
So the
where,
officer just
Yep,
persuaded him
Yep,
to,
yep.
if you
So
go
that-
back, you
Yep.
can sue against, but this is not the case.
Oh yeah. Well, yes, that's well in Europe and so forth. That's called it's the suspensory effect that you have law in place, which, from what you said, seems to be the case of what the Supreme Court states. So that case seems to be in conflict with the decisions of the Supreme Court. Oh, that doesn't make sense, because how can you honour your non-reforma obligation without a conclusion of the decision on his refugee case?
Yeah, so they requested compensation for the damage.
Yeah,
I
see. Yeah, we had some of those cases in the UK, not as simple as that, more by just straight error. And I suppose, in many countries, like New Zealand, you can't do that because it's in the Immigration Act that you've got to take matters of protection into your decisions. So it's just a blatant breach of the Immigration Act in New Zealand. You can't do that. It'd go all the way to the Supreme Court. If the Supreme Court says no, then that's the end of it. Then you would, quite rightly, could be put on the plane. And this is the ultimate court, in other words, like your Supreme Court. Then it can come to that if that's the situation. But all of your legal options have to be exhausted. That's the way we expressed it more in the UK. Have you exhausted all of your legal options? And there is suspensory effect in the UK until that happens. And if, as happened on one or two cases, there was one I sat on, or two I think I did, where they sent a guy and his family back to Colombia, one of them, and the other one was to Ecuador, funnily enough, next door, and the first one was by mistake. Somebody made an error and grabbed these people out of a detention, similar thing, at Harmondsworth, out at near Heathrow Airport, and put them on a plane and sent them back. The case was done while they were over there. The lawyers still brought the case before us, and we went through it and said, no, there was more than an arguable case. So we gave leave, in fact, to have the hearing done. We didn't actually hear that that's case. It was later done. But and it cost them £20,000, I think, to get them back. So they weren't very pleased. But that's what happens. It was just more by error. The second case, the Ecuadorian one, was a case where they had been brought back, and we then went through the claim and assessed it at the upper tier tribunal as to whether they were refugees and so forth. And we found they weren't, actually. So in that case, they'd hauled them all the way back, and then they lost, and so they could have been deported back after all that. But that's just making the rule of law work and the right to fair trial work. It's expensive if you don't get it right. But so, yeah, I think it'll probably have to go to the Supreme Court here to sort it out. I can't see how else you can avoid it here, can you? No. I can't see how you can avoid it, because you seem to have the Supreme Court rulings out of kilter in some ways with what's happening at the lower courts. But suspensory effect is not hereby. Is that in your Act? I don't know. Is that in the Immigration and Control Act or not? There's nothing that says, either in the Constitution or in the Act, that you cannot refoule somebody who is still in the process, or stop them getting access to the process by refusing to accept claims and that sort of thing. Yeah, well, what you're saying is that by actions of officers in the detention centre or something, they stopped the guy having the opportunity to meet counsel or to make his claim. Yeah. Well, it's quite right. The deportation should, after the decline, there's nothing wrong with that in law. by stopping somebody to do that's it's
Even
a
the-
question of fact in some ways, isn't it? Really. Just,
Even the Ministry of Justice, so far as also criticized to send the asylum seeker back after he lodged a claim against the ministry. So the process is going under the court. Just they ignored and then just to put in the airplane to get him back to the Turkey.
they were,
As this,
as
case
we
of
would
the-
say, they were too quick off the mark by the sound of it.
That is a Kurdish case. This is a, you know, I
Well,
also,
there's a lot of factual issues in all that. You don't know, did the guy consent to it? What happened? It's very hard to give you an opinion on that.
because
sort of
MOJ,
thing.
I think all the authorities, the final authorities, the Minister of Justice, and under the law, it's no specific provision to stop after the court process starts. I don't know. In that case, the lawyers didn't get the injunction to
Yeah,
stop
that's what you would normally look for, is an injunction to stop them being put on the plane.
Also, this case is because before lodging this complaint, but in the case of the Kurdish case or something like that, so please, the lawyers, is it possible to just file the injunction for the stop after lodging a judicial process, not to report against the minister? Is it possible? In this case, no time, but theoretically, it's possible to submit. Yeah.
If you're quick enough.
Yep,
Yeah.
that's the problem.
Yeah. Same time. Yes.
Yep.
Yeah.
Well, even an interim injunction, usually you've got to do it in a hell of a hurry. Yeah.
We have had cases in New Zealand
Mm-hmm.
where the High Court has refused an injunction because it considers that usually a second or a third refugee claim is just not, it's weak. It's being filed for
Abusive.
delay.
Abusive, yeah.
Yeah.
So that happens, yeah. In fact, one of those ones, the Ecuadorian one, I think, started from an injunction.
Recently, there was a man who was being extradited. I can't remember where to, for a crime, and he put in a refugee claim. His lawyers went to the High Court to get an injunction. The Chief Justice of the High Court looked at the case and said, "This refugee claim is rubbish. I'm not going to grant an injunction. He can be extradited." And that's what happened.
Yeah, that's probably wrong in New Zealand law, but anyway.
Yeah, it's a troubling decision.
Yeah.
And I thought at the very least they could have asked us to process his case.
Regarding
as a
access
matter
to
of
justice,
urgency.
I think one of the problems in Japan is no access to the lawyers in case of
Yes, that's the real problem.
asylum seekers. But I think New Zealand is really insured for this.
Yes,
access to
well, you
lawyers
can,
for-
from going through it, which I did before I came here, but on the detention issue,
detention.
you can, they're pretty good.
Yeah.
Getting paid is the problem, and getting legal aid, but the immigration officers are trained to keep them out of detention. And so they will, in their sort of 4-hour period and so forth, make every
Unfortunately,
possible attention to get them
in
a
Japan,
refugee.
it's
to
because
get them a
this is
lawyer.
not a criminal process. Not
No.
if it's a criminal
Purely.
procedure, justice procedures, access to justice are ensured by the
Yep.
constitution.
Yep.
But a case of the administrative sort of the means to the deportation, unfortunately, not
Yep.
such a.
That's the lacuna you're talking about. Yes, I can see that. Yeah. The case Martin was talking about there, not the one that was on the board, but seriously, we did have a case where we had a guy who was really brain dead. And,
Allan and I heard the case.
It was just after he started, and I think he thought, whoa, what have I taken on here? And he was a poor
Well, so
Punjabi guy.
thank you, Martin and Allan, for this second course. Second course will end today, but as I said, the most important, interesting session actually is left over for the Sunday, but I don't know how many actually come to join again. If you don't, if you couldn't just be give them a big applause for that. So thank you very much for the.
Thank you very much.
Yeah.